Welcome to today's video. Our topic today is wrongful act. Wrongful act, this word, is mostly related to law of torts. In law of tort, it can be explained as an act. The word act also includes both positive and negative acts, that is, the act and omission. Wrongful act is an act which is contrary to the provisions of law and causes injury to the legal rights of another person. For example, the act of trespass or tort of defamation, etc. There is a person who has a legal duty over something, over some act, and he fails to perform that duty, then it constitutes a wrongful act. And when the wrongful act or omission must be recognized by the law, and there are mere social and or moral wrongs which are not enforceable under wrongful act. For example, if a lawyer gives an opinion without taking the notice of the change in law brought about by the reported decision of the Supreme Court, he would not be guilty of an omission but of performing an act of giving his opinion in a wrong way. Now, to understand it more clearly, wrongful act means there should be some constituents of torts, means it should constitute some of the followings which may result into the wrongful act. For example, the first constituent of tort can be there must be a omission or some act in the part of the defendant, and an act or omission shall be wrong if a person sought to be held liable as was under a legal duty. The relevant act or omission should be recognized by the law, and it should not be a moral or social mistake. It must be intentionally or neglectfully committed. For example, committing a trespass or publishing a statement, a defaming statement against a person, or mistakenly detaining another person may be liable, as the case may be, for trespass or defamation or false imprisonment. There are some tests to commit the act of wrongful, to ascertain it as the committed act is wrongful. In some, the legal rights of others should not be adversely affected. All infringement of private rights are therefore enforceable, which means there is no evidence is required. However, violations of public rights are not unless substantial damage is done to the complainant in addition to the injury to the public. Private rights, all rights granted to the particular person, excluding the whole world, that is the right to body security, right to reputation, right to property, etc. And public rights belongs to the rights which are in the society members in general. It is stated that the second constituent of wrongful act can be the act of or omission must be result in legal damage, that is injuria, the term we use as the injuria over here. And damage means the harm or the loss suffered or presumed by a person as a result of some wrongful act or omission. In cases of of any kind of wrongful act, or we may say as a tort, the complainant is required to compulsorily prove that legal damage has occurred to him as a result of defendant's action or omission. Legal damage is only possible if the complainant's legal right has been infringed. Under tort, no action or damage is possible if no legal right is infringed. So the maxim, that is damnum sine injuria, expresses this proportion that from the perspective of damage presumption, rights are divided, that is absolute and qualified. That is, if the absolute right is infringed, law is definitely presumes damage even if the wrongdoer has not suffered any loss or money. Violation of absolute law is enforceable in itself without any evidence of damage, and qualified means there is no presumption of damage in that case of qualified rights, and the violation of such rights can be applied only on the basis of proof of damage. So, injuria sine damnum, this maxim means injuria means the infringement of the right conferred in the on the complainant by the law, and or unauthorized interference of the right of the complainant, however trivial it may be. But and damnum means here the substantial money or the comfort or the health or loss or the damage, that is, and sine means without that. And here thus injuria sine damnum means an infringement of law without causing the plaintiff any harm, loss or damage. There are many cases which actually talks about injuria sine damnum, and the another thing of this related to this is damnum sine injuria. Damnum means substantial damage or loss or damage of money, comfort or health or like that, and sine means without, and injuria means some infringement of right of the plaintiff by law or unauthorized interference. And here it means that damage has not accompanied by unauthorized interference of the lawful right of the plaintiff. Now, our third constituent for doing a wrongful act or a tort is that the wrongdoing or omissions are such a nature that legal remedy can be found. Legal remedy is the third necessary remedy of a tort action. In the tort, the wrongdoing must fall within the category of wrongs in which the remedy is a civil damages action. Civil injury is a tort, and but all civil injuries are not considered as a tort. And for this, the tort has evolved some maxim, that is ubi jus ibi remedium, for which means that for every wrong the law provides a remedy. So here we end our presentation that tort is fashioned as an instrument of adhering to a conduct of reasonable conduct and respecting another rights and interest also. And the main three constituents of a tort is that there must be a wrongful act, there must be a legal damage, and there is a legal remedy for this. Thank you so much.